What surprises many people filing EB2 NIW petitions is that their qualifications aren't actually the issue. In 2026, we're seeing more NIWs stalled through RFEs and in many cases denied, not because the applicant isn't strong, but because USCIS finds the endeavor too vague. And when USCIS uses the word vague, they're not talking about your field, your degree, or your resume. They're talking about how your proposed endeavor was framed. In this video, I'm going to explain what USCIS actually means when they say a proposed endeavor is too vague, why generalized NIW strategies are failing even for strong applicants, and how this issue quietly undermined cases from the very beginning. The NIW itself didn't change, but how it's being adjudicated absolutely did. What we're seeing in 2026 is a shift driven by a few factors. A significantly higher volume of EB2 NIW filings, particularly by people who don't qualify. Changes in adjudication policy, much less tolerance for generalized or template-based narratives. Historically, many NIW petitions focus too heavily on the importance of the field. But USCIS has largely moved past that. The focus has shifted from, is this field important, to what exactly is this person going to do and why does their work matter? This shift is where many otherwise strong cases start to break down. When USCIS says vague, they're not confused, they're unconvinced. This is critical to understand. Vague does not mean too short, too simple, not technical enough. Vague means USCIS cannot clearly answer these questions. What exactly are you going to do? How will you do it? Why does this matter on a national level? How will this broadly impact your field? Many petitions rely on overbroad language like advance the field, contribute to innovation, support economic growth. These phrases sound good, but without specifics, they don't tell USCIS anything measurable or reviewable. USCIS is not rejecting your ambition, they're rejecting uncertainty. If the proposed endeavor is weak, the entire case collapses. The proposed endeavor is the single most important element of an EB2 NIW petition, and also the most misunderstood. Your proposed endeavor is not your job title, your resume, your field of expertise. It is a legally framed mission statement, a roadmap for the entire petition. Every argument, every exhibit, and every expert letter is supposed to support that endeavor. When the endeavor is unclear, USCIS cannot assess national importance. USCIS cannot evaluate whether you are well positioned, and they cannot justify waiving the job offer. At that point, denial becomes almost inevitable, regardless of how impressive the resume looks. Many EB2 NIW denials come from applicants who are genuinely strong but made strategic mistakes early on. Statements like, AI is important, healthcare matters. USCIS already agrees with this. That's not the test. The test is how your specific work advances U.S. interests. Now let's talk about mismatch between background and goals. This often looks like a degree that suggests one path, a work history that suggests another, a proposed endeavor that jumps too far ahead. When the narrative doesn't line up, USCIS questions credibility. Many petitions explain what the applicant wants to do, but not how they will do it, when results are expected, what outcomes can be measured. Without that, USCIS sees aspiration, not a plan. Now let's talk about employer-centric impact. This is another common issue in framing impact almost entirely through a company, a single employer, or internal business goals. USCIS needs to see how the work benefits the United States and your field broadly, not just the organization. This is where many strong applicants go wrong, not because they aren't qualified, but because the strategy was never clearly defined from the beginning. In our free case evaluation, my team and I look specifically at whether your proposed endeavor is actually specific enough to withstand USCIS scrutiny before you file. If you're unsure whether your NIW strategy is too broad or too vague, you can request an evaluation using the link in the description below. Vagueness isn't a small flaw. It infects the entire petition. Here's what typically happens. A weak or unclear endeavor leads to a weak national interest analysis. USCIS questions whether the applicant is well positioned. RFEs are issued, or the case is denied outright. And once a petition is filed, it is very hard to fix these issues. A poorly framed initial filing can damage the record for appeals, motions to reopen or reconsider, future refiling. That's why clarity at the beginning isn't just helpful, it's legal protection. EB2 NIW denials in 2026 are often not about qualifications. They are about clarity. USCIS isn't rejecting strong professionals, they're rejecting unclear endeavors that are not in the national interest. Other issues show up in other high-skill immigration petitions as well. In my next video, I explain why even EB1A cases that meet multiple criteria can still fail at the final merits determination, and what USCIS is really evaluating at that stage. I recommend watching that next video right here. I'll see you there.